Oh, live stream back. Okay, sorry about that. Looks like not going to bother adjusting screen names now, but I think we have everyone. Yeah, okay.
Can I ask the last name of Kent?
Taylor, Village of Little Chute.
What was the last name? I'm sorry.
Taylor, Taylor.
Thank you.
All right. So yeah, it looks like we're good to go. All right, so we did go into breakout and parties had discussed with
Yeah.
staff adjusting the issues. Didn't sound like there was an agreement, but we were working toward one. So I just want to check issue C. We're all in agreement. If we end the issue with the statutory citation, we can live with that change.
Yes, Your Honor.
Okay, so
Yes.
now, okay, issue A and B, maybe, so who is the most objectionable party in the breakout room? Want to just discuss what happened, what their objection is, where we're at this point?
I believe that would probably be me.
Okay.
I think a resolution was proposed at the very end of our discussion, and if I may read it, and if it's agreed to by everyone, we might have this issue resolved. For issue A, whether pursuant to Wisconsin statute section 66.0821 parent 5, HOV MSD's volumetric rate is unreasonable and unjustly discriminatory as applied to Kaukauna because Kaukauna alleges HOV MSD's rates fail to account for the fact that over 25% of Kaukana's wastewater does not enter the interceptor. I believe we were moving towards a potential consensus as that being the phrase for issue A. And then regarding issue B, whether under Wisconsin statute 66.0821 parent 5, HOV MSD's adopted cost allocation methodology for its interceptor project is unreasonable and unjustly discriminatory as applied to Kaukauna because Kaukauna alleges it uses only a small portion of HOV MSD's interceptor.
Okay. So who's most objecting to that wording?
I don't think that the city would have any objections to that wording.
Okay. And the villages, any questions on that?
Well, I don't object, and the reason is we started out with wanting to stop with unreasonable discriminatory. Kaukauna wanted to assert the reasons that they were asserting was unreasonable.
Mm-hmm.
Neither of us wanted to conclude that that was a given fact. And so by making that an allegation or assertion rather than just a foregone conclusion, we feel more comfortable that we're not precluded from introducing evidence as to why we don't think that's the controlling factor.
Yes. Okay, that's fine. I think we could have proceeded with either wording with the understanding that parties can bring to bear at the hearing the evidence they wish to support or refute what's been stated in the complaint. But the issue works for me, and it seems like we have agreement on all sides. So we'll use the wording that Attorney Nelson described for issues A and B. And for C, we'll use the proposed issue, but it'll end at the statutory citation. So everyone okay with that?
Yes, Your Honor.
Yes.
Okay. So schedule, that's another item that was put on the notice of pre-hearing conference. I'm going to put our screen share back on. Will not look the same as it did before, but here we go. There we go. Oh, where did everyone go? There we are. Okay, so in terms of the schedule, I think I heard that there may be an issue with the briefing dates, but anything else giving people trouble?
No, Your Honor, and the briefing dates were raised by me, and I thought, perhaps two briefs in back-to-back weeks was um, a bit intensive, and we just request a little bit more time for each of those briefs. Other than that, no objections to the proposed schedule.
Okay. So
And
what
the
would
city
the,
has,
oh, go ahead. What's that?
oh, I'm sorry, Your Honor. The city has no objections to the revised schedule for the briefs.
Okay, so what was the date that's being proposed as an alternative?
Proposed date for initial briefs by Heart of the Valley was the March 7th date at 1:30 p.m. And then the proposed reply date was March 21st, 2024, excuse me, at 1:30 p.m.
Yeah, good catch. So usually our briefs are simultaneous for all parties. So it'll be initial brief for all parties and reply brief for all parties, just so you understand. Is that raise anything new for anybody, or is that what we were intending?
Not from Heart of the Valley. Simultaneous
Okay.
briefing is fine.
Okay, all right,
Same for the city.
all right. Yeah, and just checking with staff, there's no timing concerns here.
No, Your Honor, no issue from staff on the schedule change.
Okay, so we can adopt that briefing schedule as proposed here today. And that's it for the schedule. So I did want to,
Your
anything
Honor?
else? Yeah,
Oh,
go ahead.
I did have one question, just a clarification on the offered evidence, direct parties and commission staff.
Mhm.
Interveners would also submit direct testimony on that date. Would that be right?
Yes.
Yes.
And it's probably not. So this is a little bit different than our normal schedule because there is no surrebuttal in writing here. But this is the schedule staff gave me. So I'm assuming there's either a reason for it or everyone seems to be okay with it. But there's typically a surrebuttal round of written testimony. And typically we have, it would be, yes. Well, let me just answer your question. So yes, interveners would be involved, would be parties. So interveners are parties. I guess that covers your question. But in terms of direct, it's just all parties filing direct and commission staff, all parties and staff filing rebuttal, and then we'll take the rest at the hearing. Never really done that before, but I'm willing to try it if there's something about this case. It's a complaint case, maybe the facts are more straightforward, or kind of everyone else but me knows what's involved here in terms of documentation and expert opinion. And then really, so surrebuttal usually ends up kind of sifting and winnowing the actual contested facts and issues in the case come out in surrebuttal. But if parties are okay with 2 rounds of written testimony, I'll be okay with it.
Your Honor, I would say that I didn't make that catch, and I looked at the schedule, and that's a really good one. I would be surprised if the issues are as narrowed after just 2 rounds as they would otherwise be with the surrebuttal. So I'd be interested to hear staff's thoughts on, or the rationale for not having surrebuttal, because I do think that would be helpful here.
Yeah, I don't think commission staff would object to a round of surrebuttal. It's mostly, with complaint-led dockets, we're kind of working off of a historical framework of what has worked before or what has been done in the past, particularly with sewerage complaints. They're few and far between, generally speaking. And going off of that, in the past, surrebuttal or the need for surrebuttal has been sort of covered by what can be presented at hearing. And so in the hopes of moving this along and getting a hearing on the books, getting things moving forward with this docket, and hopefully working towards a resolution with the commission, this was the schedule that we came up with. I don't think that there's an issue with moving it out. I don't think commission staff would have an issue with moving it out if we were to rearrange to allow for a 3rd round of written testimony. It's really just whether or not there's a need for that, or whether or not that can just be presented at hearing in the hopes of tightening up the schedule.
With having pushed the briefing schedule back, it seems like there would likely be an extra week within here in which we could include SIR rebuttal. I don't think from the city side we'd have any issues with the other dates being moved back consistently.
And I
that
think
still
in
gives
there
us
it
a good
really
amount of
just
time. I'm sorry. Go ahead, Zach.
Oh, excuse me. I didn't mean to interrupt you. I just was going to say, I think from there, then I think it just comes down to whether, the judge's schedule can accommodate such a hearing.
Yeah, the hearing date,
That's been pushed back.
we can be flexible with the date. I'm certainly there'll be a day at some point in the future from February that we can do it. Okay, well, I guess if it really boils down to whether the scenario here would warrant SIR rebuttal as we sit here today, it looks like it may be helpful. Do parties see that?
I would agree with that, Your Honor.
Okay, all right. Yeah, so because that's what the meeting confer is really for, but we could have done that before, but I would say let's say that with some fear of losing us all again on Zoom, we'll do another breakout room and give you some time to come up with a new schedule. We can add the SIR rebuttal, and just so you know, another option would be to have complainant go first and then respondent respond. But that would probably add more rounds of testimony then. At this point, parties would be expected on direct to put all their cards on the table on direct. They shouldn't be presenting new issues that could have been raised before direct testimony in rebuttal. So that's our standard. So just be mindful of that. If you're responding to another party's direct and you can tie it into responding to direct, that's fine. But since if we're going to have all parties go first at the same time, then I want to see your complete case being presented in those filings. So with that, let's do another breakout room. I'll give you another 10 minutes and you guys can come up with an alternative schedule.
Judge, before we do, can I ask one question
Yeah,
about,
of course.
maybe it's a compound question. In terms of written testimony, what format are you anticipating that? Is that question and answer or affidavit type statements, or how is that?
Okay, so actually we'll get to that when we go to other facilitating matters, but if this affects your decision on timing of the testimony.
No, it won't affect my decision on that.
Okay, yeah. All right, so let's go into breakout. I'll put you guys in breakout and then we will reconvene another, I think 10 minutes will be enough. Yeah, okay.
Yes.
So we'll just try to be a little more careful when I push buttons here. Okay, looks like we're good. It's weird. Okay, are people coming back? We're done with our scheduling breakout. I can close the room if that helps. Looks like everyone's muted for some reason.
I think we just joined muted.
Yep.
Oh, okay.
Yes, Your Honor. I think we have a
Okay, let me close
schedule.
this room without me. Okay, close room. All right, there. Everyone should be joining us that hasn't done so already. So we need our court reporter, for example.
I'm here.
There you are. Okay.
When you say 10 minutes, I take 10 minutes.
Yes, so that's true. I was expecting it to go longer even. So that's good. Good thing. So I'm going to turn this screen share off. All right. So we're ready to go? Debbie, are you ready?
Yes.
Okay, great. Okay, so who wants to chime in first with the schedule?
I can, Your Honor.
All right.
So the proposed schedule would be keeping direct and rebuttal written testimony at January 23rd and February 6th, adding in a round of written surrebuttal testimony on February 14th, and then hoping per the court's hearing schedule that February 21st would work for a new hearing date. And then the brief deadlines would remain at March 7th and March 21st, respectively. And then the other dates regarding errata testimony, witness verification affidavits, revised testimony, et cetera, would all be shifted to accommodate that new hearing date. So likely a errata testimony and replacement exhibits deadline of February 19th, then 2 days before hearing. And then here we have 5 days after hearing, it seems, for the affidavits and revised testimony. That actually probably is because it's a Wednesday. So I guess it would be then the 26th for those dates.
Yeah, it's usually 3 working days. But we can accommodate a longer time if that's what.
I think the 26th would still work from the sounds of our discussions, but
Okay.
others can weigh in if not. And that I think covers then the dates, the others being just shifted to accommodate that new hearing date.
Okay.
But the
And
brief
Tom?
staying on the 7th and the 21st.
Yes.
Any comments then? All right, all in agreement? Okay, so we'll set the new schedule as described by Attorney Peters. And we'll move on to facilitating matters. It'll be useful to share screen of that document. Just that bit. So yes, facilitating matters are really covered in the attached, what will be ordered in the docket. It's attached as a draft, or proposed facilitating matters, but it's our standard that we use and typically apply to contested cases. However, they can be modified at the pre-hearing conference or before they're put in place in a particular case. So I guess first of all, are there any changes that people when they reviewed the facilitating matters order that's proposed, any changes they feel are necessary to proceed with this case? No?
No.
Okay. And then any particular questions about the facilitating matters? I think we did have one from the villages about formatting of testimony. So I can direct you to page 4, and I don't want to make it too big on the screen share. So it does describe the contents of the what should be in written testimony, and then format on page 5 describes what we accept for written testimony. And I can also your best, I guess it's very rare that someone actually files this correctly. So I hesitate to tell someone to look on IRF and go and find another filing to use, because there's probably some nuance that wasn't caught in every filing. But typically, commission staff filings are typically filed according to this format, for the most part. And so that's one point of reference you could use to get a sense of the look and feel. I'm also working on some draft documents that display sort of a template of what you should use for testimony and exhibits. They're not completely finalized, but I think I feel confident enough if I shared those with the parties that, don't take it as gospel. They're just suggestions, but it does kind of illustrate what we're expecting. So I can send that off to parties and staff by email, hopefully before the end of the day. So testimonies on page 4 and 5, and exhibits follow page 9, exhibit contents, and then page 10, format. But yes, there's a lot of details in there. But we were one of the first entities to have electronic filing, and you'll see a lot of this is pretty standard nowadays. But just to have documents look and feel the same when you're trying to view them on the screen, it is very helpful to stick to the standards. So biggest penalty will be I'll make you refile. And if I can catch mistakes before rounds of testimony come in, I'll let everyone know, don't repeat this particular problem in the next round. It's in the best of all worlds, I can get to everything beforehand. If not, we do have the errata process, and we have after the hearing, we have refilings to correct all these problems. So it's not necessary to kind of keep filing in order to catch up with mistakes. We kind of we wait till the end, take all the testimony, all the errors, all the changes that need to be made are made in the final version after the hearing. So that reduces some of the workload and trying to follow these rules, and also trying to incorporate any errors that we find during the course of the hearing. So you'll see parties try to beat the gun and file something revised before the hearing, only to find out that at the hearing there need to be a correction made. And my goal is that the commission read the written filings, and they don't need to refer to the transcript to look for corrections to those filings. So we'll incorporate all the corrections into the final version of the written documents. Of course, the hearing transcript will include all the cross and all the debate and motions or whatever. But in terms of the written testimony, in the end, the final version that I receive will be the fully corrected version that we all accept as the final. So hopefully that helps. Touches a couple of different things for everyone.
Your Honor, I do have a question. So this is a complaint case. How does the complaint get put into evidence? Should we have one of the city's witnesses put in the complaint, or does it go in similar to an application? How does that handle? And I guess I would also be interested in the answer to the complaint, because certain facts are agreed to.
Yeah, that's fair. So we can do it in a more formal way. That may be useful here. So you'll see we have documents that are described as particular exhibits that we describe here. I call them special exhibits. But basically the idea behind a special exhibit, so for example, like the data request response exhibit and an environmental assessment exhibit, they're not real documents in a way. They're just documents that offer what's already on IRF. So all they really consist of is a cover page and a page that contains the link to the IRF document. And that's the most formal way to offer something that's on earth, that's not already an exhibit, but something we don't need to refile. So I think that would fall into place. So we do that for applications, and that would also fall into play for the complaint and the response. So if the complainant wants to file a complaint exhibit, they can either make it a generic where it's just Kaukauna complaint, EX Kaukauna complaint, or they can have it come in with the witness, just making a witness's exhibit. It doesn't really matter to me so much. And the same thing for the respondent, if they want to put the answer in and offer it as an exhibit, I would say, use the format of a special exhibit. So we're not repeating things. We can just link right to the document that's already filed.
But Kaukauna would want the answer in because there are certain, like I said, stipulated facts that we wouldn't need to then put in through our witnesses. We just want to refer to the complaint and the answer for that fact. And so that could be beforehand so that we can refer to those in our testimonies.
Absolutely. Yeah. Well, beforehand.
Yeah. See, because isn't this normally after the fact?
Not actually, no. It just ends up being after the fact because people don't do it at the right time. So all direct is going in. So why don't we okay, let me just check out what we have so far. Yeah, and I have to say I'm just taken aback because we're thinking ahead, and that usually doesn't happen so much when it comes to document filing. So I'm glad to be doing this. But what do we have so far is so we just have, so it's the two documents we have a request. I'm just going to adjust the screen share here. So just we have on Earth is the response, the request to open the document complaint. That's the document where that you Attorney Cubs is considering the complaint. Is that right?
Yes.
Okay, and then the response, we're calling it the answer, but it's the response from Heart of the Valley. And that's the document we're referring to as the answer so far.
Yes.
Right.
So I think it's fair. Let's just label them now. Our standards usually, will be EX dot dash, and then the party's acronym or short name, whatever they decide to use. And I'm assuming City Kaukauna will be COK. Heart of the Valley, we'll just call it HOV. And then dash, and we can use response for Heart of the Valley, and we can use complaint for Kaukauna. And just so you can cite to those documents as if they were filed that way in your direct, but just make the offer indirect. We can just proceed with the assumption that you'll do that, and if it's not done, we will make you do it. So if you want to refer to it as the exhibit, and then not sure if is this just one document in here? There's some attachments. So you would cite to it as the exhibit, and you can cite to the exhibit attachment A and the exhibit by page number or paragraph number, however you want to do it. I think that'll work.
Just so, for example, in Kaukana's testimony, we would be able to cite, for example, to our complaint, but also Heart of the Valley's answer as if it was submitted. We can assume it is.
As it was offered as an exhibit. Yeah.
Okay.
Mm-hmm. And yeah, and again, if you get the wording wrong, it'll just be corrected on refiling, which will happen after the hearing. So it's not going to, impact the way you process the case.
Okay.
But I might catch you on that because we'll be, citing that a number of times in probably every filing. So we want to make sure we catch that and do a correct version of the citation, at least. Yeah, and just so you know, so when it comes to complaints, responses, they're obviously part of the return record as pleadings. The commission will get them at least as a pleading, whether we actually offered them into evidence. But I think, especially because we're going to be relying on the assertions or denial, it makes sense to just formally introduce them as exhibits. So that's not a problem. Thanks for bringing that up. So I don't know if there's any other obvious issues that might relate to what we just did here, but are there any other questions about the facilitating matters? Everyone seems to have used IRF before, so that's not an issue now. The one question I did have, though, actually doesn't relate to the facilitating matters order. So just want to make sure we're okay with that now. So my other issue was the format of the hearing. We can do an in-person hearing if that's what if there's a reason for it. No problem with that. I've seen that Zoom hearings, except for going to breakout rooms, so far have been pretty useful, pretty expedient and beneficial to everyone to be able to meet this way and be able to view documents and share the screen this way. But I guess what I'd wonder is that if the hearing is going to be more of a technical nature, if it's going to be more of experts or financial documents being disputed or analyzed, that may bode better for a Zoom hearing. But if we're talking more about what was said by someone at some point and what was disputed by someone else, or a personal dispute or some sort of scenario like that, it may be useful to be in a in-person setting. So any thoughts about whether one is favored over the other?
I tend to think that we will fall in the first category, that it will be more engineers, experts, technical, and not really a credibility issues. But I don't know how the other lawyers feel on what their case will be.
I agree with that, Your Honor.
Okay, that was Attorney Nelson. I'm sorry.
It was, yes.
Oh, thanks. Okay, any thoughts from the villages?
Mr.
Gary,
Kaler, I was going to say I could see his lips moving, but
Oh, sorry. Yes. Assuming all testimony and exhibits are submitted in advance, what do you really anticipate will be live testimony, if anything, or other exhibits that haven't already been introduced?
Yes, that's a good question, and I'm glad you asked it now because for a new participant that may be an issue. So when typically happens, what's allowed as a standard matter of course in our hearings is that, and it's in the facilitating matter somewhere, but I'm not going to take the time to find it. But what usually happens is we do allow a person live, a witness who's already participated. Well, I can't go that far, but let's just say at the hearing, witnesses are allowed to make a final statement based on what was stated previously, the prior statements of another witness. So if the last statement was surrebuttal, the witness can conduct a surrebuttal on the stand and get on the last word out for that witness. So there may be additional testimony live. We try to keep it limited and we try to keep it based on the last statements that were heard. And that could either be, I'm sorry, it could either be surrebuttal, written surrebuttal, or it could be what was stated at the hearing. So anything before you, before your witness goes on the stand, that witness can then respond to what's been said or submitted as a final surrebuttal. Having said that, we can recall witnesses in case we need clarity. If one witness has already been excused and the issue comes up, now we have something else in dispute. We can recall a witness, have them get their piece, make their piece as well. But so there things do happen at the hearing. Although a lot of times I'm not sure why, but yes, we do. There's plenty of evidence at the hearing. Also, we do allow exhibits to be filed before the hearing that haven't been offered before. Mostly those are for impeachment purposes, or if there's some good cause for a delay. This does come up in certain cases, especially where there's sort of moving targets when we're forecasting things like future rates or future costs. So, that might not be the scenario here. I'm hoping that probably wouldn't be applicable here, but that's our standard. That's how our standards work in order to accommodate those kinds of situations. So you'll see in the facilitating matters order, the Zoom supplement, because we're not at the hearing room, I require that we share those documents, any documents to be offered that weren't submitted previously during the rounds of testimony need to be shared 24 hours, at least 24 hours before the hearing. So again, that's not, oh, we could have put it in on direct and now we're putting it in now. This is stuff that's responding to the last round of testimony, something that couldn't be offered before. There's good cause. There's a little more of a gatekeeping process there to make sure. Plus, there's also an opportunity to object because you haven't had that opportunity yet. So yeah, there could be some work to do at the hearing. It usually is not definitive. There's usually no smoking guns or definitive, gotchas moments at these hearings. So I'm not expecting that to occur, but we do try to gather as much evidence as we can. And if it's required to do that at the end of the hearing, we will. So having said that, that's kind of why it's more of like, what's the nature of this case? What kind of witnesses are we going to be presenting? And I think Attorney Cubza succinctly stated what I was trying to say. Is this going to be a credibility issue? Is it he said, she said, or is it going to be experts arguing, which they mostly do and like to do on paper? So, I mean, we can also
just one thing though, the hearing does provide the opportunity for cross-examination, where you haven't had that opportunity before.
Yes, that's correct. That's really the main statutory reason for holding the hearing at this point would be to offer the opportunity for cross. You're right.
So that means that any witnesses who submitted written testimony must be present for the hearing.
Yes. Now there's some caveats. So part of the facilitating matters order is that the day before the hearing, and it's really more of an organizational purpose, this process is that the parties and staff submit to me an email indicating whether they have cross for the witnesses, which witnesses they have cross for, and some other details, whether they think they need to go into closed session, etc. So it's really meant to give me a sense of how long the hearing is going to be, how to manage the hearing. It's kind of become a little bit more because parties have now served each other these documents, and they tend to feel like, well, that means my witness, if there's no cross from my witness, that means they don't have to show up. But that's not the case. I still need to excuse the witness before the witness can be set free, so to speak. So if there's no indication that witness has no cross, they don't need to be here at the beginning necessarily, but they need to be available. And they need to be, I would think they should be monitoring the hearing at least. So, and the reason why we do that is because I may have questions still, or a commissioner may join us and have questions. So I can't necessarily say there'll be no questions or nothing for the witness to do, even though parties have indicated that there's no cross. So, it doesn't mean that they'll be at the hearing very long either. We can address that at the beginning of the hearing, whether witnesses can be excused because there are no questions. There's still the matter of having the witness verify the filings, and there's an opportunity. We could just put them on the stand and have them do it quickly, or there's an opportunity to file an affidavit and do that in writing. So that's all that process is discussed in the facilitating matters order. But I'm glad you raised it because people are confused by the options. So just be mindful that, yeah, even if there's no cross, it doesn't take the witness off the hook for at least being available for the hearing and being here if called.
So they can be present either remotely or in person?
Yes. So the notice will say, yes, if we do a Zoom only hearing, they of course will only be connected through Zoom. If we do an in-person hearing, we can take witnesses on Zoom. I think we would want the attorneys present at the physical location. Witnesses, I'm not so concerned about where, how they join us. But you'd have to weigh what you think is best for your client in terms of having them appear or be connected. And parties can, so I won't say object, but I think we do follow, there's a statutory process for objecting to a telephone appearance. And I'm assuming that I think what we end up doing is we basically say that the party can do that at their own risk if they want a person to appear by telephone or in this case on Zoom. I would recommend that they make sure that parties are agreeing to that, because a party may object and say, no, I want that person here today, and today may be too late to get that person here. So I think that's the portion of the facilitating matters that I have on the screen here. Form of witness appearance. Okay, so so if this document really won't apply. But it's if we're only meeting in physical location, you need to file a motion to appear in a different way. So when we switch to Zoom, I think it's pretty much presumed that witnesses can appear by Zoom. But like I said, I think if someone were to object, we just have to hear that objection and see if that would be valid to have that person actually show up at the hearing. So it would just be wise to get agreement to that if necessary. But here, this will be a Zoom hearing as well as if we do a physical location, it'll be both. So I don't really see, that there's going to be a good reason to bring them in person when we're allowing a Zoom connection. So So anything else?
And when will you make that decision, whether it's Zoom or in person?
Well, I think it seems like Zoom will work for everyone at this point. Is that what I'm hearing? So yeah, we'll just set it as Zoom only. And I think it'll be basically, so I will be issuing a memorandum from the pre-hearing conference, basically reiterate what we've done here today. It'll include the facilitating matters order again, but it'll be ordered in the case as applying to this case. And it'll indicate in the schedule that the hearing will be Zoom only. The notice as well will show, where it's located. It'll have the hearing will have no physical location is what the notice will say. And that will all appear on Zoom. So that's, the official version will be in those documents. Okay, is there anything else? So that the memo from the pre-hearing conference will take a few weeks to come out because I will be away for some time over the holidays. So when we get our transcript for the pre-hearing conference, use that to guide you on the schedule and the issues at this point. But I'll be basically packaging this notice of pre-hearing conference as the memorandum. So we'll have the issues and schedule stated as we've agreed to do at the hearing. So, all right. Anything else we need to review at this point? No?
Not from Heart of the Valley, Your Honor.
Okay.
Not from the city.
All right.
Your Honor.
Not
Okay.
from the village.
Okay, sounds good. So thanks very much, everyone, and good luck. And we'll see you at the hearing. Take care, everyone.
Thank you.
Thank you, Your Honor.
Bye-bye.